Good evening, everyone. This is the Vocational Science of Freedom, Saturday night Civics and Sovereignty class, and tonight we're going to be going over a little bit of history of land title in early America. If you are not a member of the Vocational Science of Freedom Gilded server and you would like to be, you can join the Vocational Science of Freedom Gilded server by going to the Vocational Science of Freedom YouTube page and clicking on the little server icon up in the banner, and then that will prompt you to be brought to the Gilded server. And I suggest that you download the application and run it that way. You can run it off of a web browser, but it's always better to run it off an application. And then when you click up here, there'll be a little apply or follow button. Make sure that you hit apply and make sure that you answer the questions so that you can then get into the server and join in all of the rest of the fun discussions that we have here about civics and sovereignty and American freedom. So tonight, I picked this little document for deed history because tonight will probably be the last night that we'll do, at least for this round robin, probably the last night that we do land rights and title. And I posted the link into chat for the download. So if you want to download the document that I'll be going over tonight, you can do so. Just scroll up a little bit and it's in the mega folder. And of course the live stream's up and running. So time to relax and just a little bit of history about land law in early colonial America. Now I copied and pasted this off of a website that I found fairly informative. I do not, unfortunately, and forgive me, know the exact website that I did pull it off of, but and I don't think there's any hyperlinks in here to be able to take you back to it. But it was a fairly good short little beginning synopsis of what land law was like in early America, colonial America, and it gives some good information as far as understanding these terms. I'll just begin to read and I'll do a stop and start whenever I need to, as I usually do. I'll open up Bouvier's Law Dictionary and I'll start with deed. And this is a very important thing that everyone needs to do. Make sure that you are going into Bouvier's Law Dictionary, which is on the Vocational Science of Freedom free online law library. This particular version of Bouvier's Law Dictionary has been up for a very long period of time, or been around for a very long period of time. It was the 1856 edition, and this is the edition of Bouvier's that you want to use whenever you're dealing with anything constitutional by no less than 3 separate acts of Congress. So let's see what a deed is. Okay, deed, conveyancing contracts. A writing or instrument under seal, that's important. It has to be under seal. It has to be under your seal. That's one of the main reasons why you have to get your own house seal made, because you have to use your own seal. Because when you do sign it, okay, that's one thing, but if you seal it, that's considered a covenant. And I could get into covenant, but let's just finish up with deed here. Writing or instrument under seal containing some contract or agreement and which has been delivered by the parties, meaning that both parties had a copy of the other side of it. This applies to all instruments in writing under seal, whether they relate to the conveyance of lands or to any other matter, a bond, a single bill, an agreement in writing, or any other contract, whatever, when reduced to writing. Somebody's got a hot mic. Okay, so a deed applies to all instruments in writing under seal, right? A deed is not just something that deals with the conveyance of land. A good way to think about a deed is that a deed is a thing done. That's a deed, right? So it's an instrument under seal that's a thing done. So are the Vocational Science of Freedom status docs deeds? Yes, they are. Because they're instruments in writing under seal. They're a thing done, right? Okay. And they do relate to all kinds of other matters, including land and your property and so on and so forth, and are also an agreement in writing, right? Okay, so are any other contract, whatever, when reduced to writing, which is sealed and delivered, is as much a deed as any conveyance of land. Just important to remember that a deed is not just about land. And then it says signing is not necessary at common law to make a deed. Well, then what is? The seal. If you seal something, it's a deed. You don't even have to sign it. Not to say that we don't want to sign your documents, but point is that signing is not necessary at common law to make a deed. Okay. Deed in its more confined sense signifies a writing by which lands, tenements, and hereditaments are conveyed, which writing is sealed and delivered by the parties. That's how most people think of it. But that's not the true and full definition of it. It's anything under seal, any writing. The formal parts of a deed for the conveyance of land are 1. The premises, which contains all that precedes the addendum, namely the date, the names, the descriptions of the parties, the recitals, the consideration. This is what you actually traded one human being, one man or woman, to another. That's lawful, not Federal Reserve notes, but actual consideration, meaning gold or silver. The receipt of same, right? Because what do you do when you're supposed to receive something? You're supposed to give someone else what's called a bill of sale so that they have a receipt that, yes, they paid you and you agreed to that, and there's the receipt, right? The grant of whatever the land is as far as granting is to them. The full description of the thing granted and the exceptions, if any. The addendum, which states that estate or interest is granted by the deed, this is sometimes done in the premises. So, okay, so what's the addendum? So what's the addendum? The addendum is the clause, and you'll see this, and there's a addendum clause in every single original land patent. And the addendum clause in all the original land patents states that the United States of America, so on and so forth, grants to whoever the sovereign was that they granted the land to his heirs and assigns to have and to hold forever. I might have butchered that slightly, but that's basically what it says. Okay? So that clause, to have and to hold forever, that means that it gets transferred in what's called perpetuity from one man to the next, to the next, to the next, to his heirs or assigns, because he could possibly assign it and create a deed and give it to somebody else other than his heir, obviously, if he wanted to sell it, whatnot. But forever, so that the right to the land is transferred. So what right are we talking about here? We're talking about a allodial title, not just the right of use. We're talking about absolute allodial title, to have and to hold forever. Okay, so that's the little thing on addendum. The addendum, which was formerly used to express the tenure by which the estate granted was to be held, but now that all freehold tenures have been converted to scoage, the tendum is of no use and is therefore joined to the addendum under the formula to have and to hold. Right, again, to have and to hold. Da, 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 da. That's the clause. The redendum is that part of the deed which the grantor reserves something to himself out of the thing granted as a rent under the following formula: yielding and paying, blah, 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 blah. That's what, if he wanted to keep a rent or something like that. Or if you wanted to keep, say, the mineral rights. Yeah, that's something that usually happens as far as reserving something to himself. The conditions upon which the grant is made. The warranty is that part by which the grantor warrants the title to the grantee. This is general when the warrant is against all persons, or special when it is only against the grantor, his heirs, and those claiming under him. So a warranty saying, I'm saying that you are having all of this and you get all of it, right? And when you say this is general when the warrant is against all, it should say persons and people, but when something is general, you want to think of the word general in law as basically encompassing everything, or being total is another way to put it. So yeah, I'll just leave it at that for now. Number 9, 7th, the covenants, if any, these are inserted to oblige the parties, or one of them, to do something beneficial to, or to abstain from something which, if done, might be prejudicial to the other. Now, to get back and talk about the Vocational Science of Freedom status doc sets, that's what we do. We force them under the KW to abstain from administration of our estate in any way, shape, or form, right? Which, of course, would be prejudicial to us. 10, the conclusion, which mentions the execution and the date, either expressly or by reference to the beginning. And then 11, circumstances necessarily attend upon a valid deed are the following. It must be written or printed on parchment or paper. There must be sufficient parties. A proper subject matter, which is the object of the grant or the deed. A sufficient consideration. Again, a sufficient consideration. This is why we have in the KW, which is one of the Vocational Science Freedom status docs, this is why you have in the KW the offer to any administrator who does their job to pay them from a percentage of the estate in silver for doing their job. So they can never come back and say, well, this isn't a lawful contract because it doesn't have an offer of consideration. Yes, it does. Okay, that's why that's in there. 5, an agreement properly set forth, which of course it does. It must be read if desired. It must be signed and sealed. It must be delivered and attested by witnesses. It should be properly acknowledged before a competent officer. Now, that last part, be properly acknowledged. You can acknowledge your own documents, and the witnesses can acknowledge that this is a deed done as well. Okay, what they're saying here from a standpoint of transfer of land is that you would have it done by basically going before either a land title or a notary or a judge or someone else saying that they've acknowledged on the public record that the transfer has happened. It ought to be recorded. This is why you file everything on the public record when it comes to the Vocational Science of Freedom status doc set, because you need to record it. Now, does that say registered? No, it says recorded. A deed may be avoided by alterations made in it subsequent to its execution when made by the party himself, whether they be material or immaterial, and by any material alteration made by a stranger. So from the standpoint that when you do a deed, it's a thing done, it is your will. If someone else comes along and tries to alter it, say somebody comes along and says something about the deed that wasn't in the deed, meaning people lie, like attorneys, then you can avoid that deed because they lied about what was originally in it, or they tried to alter it or change it, which you can't do. And that's the reason why there's all kinds of criminal statutes, both state and federal, against anyone altering, secreting, destroying the public record, because that's exactly what this protects. Or it should say those statutes are exactly what this is bringing up to protect against. By the disagreement of those parties whose concurrence is necessary, for instance, in the case of a married woman, by the disagreement of her husband, by the judgment of a competent tribunal, by the judgment of a competent tribunal. Yeah, right? Like a jury of 12 members of the peerage. Once that jury of the 12 members of the peerage makes a determination on something, it's over. Because, as it clearly states in the federal constitution, the jury's decision, being a competent tribunal, cannot be retried in any court except by the common law, right? Just remember that. Important note. According to Blackstone's commentaries, deeds may be considered as one, conveyances at common law, original, derivative. First, the original are feoffment, gift, grant, lease, exchange, and partition. Derivative, which are release, confirmation, surrender, assignment, defeasance. Conveyances, which derive their force by virtue of the statutes of use. Okay, notice that. Conveyances, which derive their force by virtue of the statute of uses. This is how they're running everything now. They're running everything under the aspect of uses. Uses and use of fructuary, right? That you have the right to use it, but you don't actually own it. so that the corporate state can say, oh, well, we hold it. We have the title to it. No, not if I claim it, and not if I claim the addendum clause in the original deed, which is the first land patent, right? Covenant to stand seized and uses, bargain for sale of lands, lease and release, deed to lead and declare uses, deed of revocation of uses. So this is how they're doing everything. This idea of bargain and sale of land, that comes under what? Comes under the aspect and idea of uses, right? It's not dealing with actual transfer of a allodial title. Okay, the deed of bargain and sale is the most usual in the United States. The deed of bargain and sale, what did it just say here? What is bargain and sale under? By force of virtue of statute of uses. The deed, bargain and sale, is the most usual in the United States. There's your proof right there in just reading the definition of the term deed, of what they're doing in America, particularly under the Torrens registry system, which we covered a couple weeks ago. But I suggest everybody go back and listen to it again, because this will bring you back to understanding what they're doing. So, via bargain and sale, Chancellor Kent, of his opinion that a deed would be perfectly competent in any part of the United States to convey the fee if it was to the following effect. I, A.B., meaning I, John Henry, in consideration of $1 to me paid by Jane Doe, do bargain and sell, or in some of the states grant, to C.D. and his heirs in New York, Virginia, or some of the states' words, and his heirs may be omitted, the lot of land describing it, meaning from such and such a place to whatever else, meaning the meets and bounds, the land description, witness my hand and seal. So again, do bargain and sell. What is bargain and sale of lands? Again, under use. Title deeds are considered as part of the inheritance and pass to the heir as real estate. A tenant in tail is therefore entitled to them, and chancery will enable him to get possession of them. The cancellation, surrender, or destruction of a deed of conveyance will not divest the estate which has passed by force of it. Will not divest the estate which has passed by force of it. What? The cancellation, surrender, or destruction of a deed of conveyance will not divest the estate which has passed by force of it. If they come along and they have tried to destroy all of the land records of America, that does not divest our estates which have passed by force of it, meaning we have forced our way into claiming the land and holding it under a allodial title. Can't be divested once it's passed by force of it. Once you act on it, once you put down your declaration of allodial lands and you act on it, I don't care what they did, how they've been trying to destroy the land record through the Torrens registry system, through all these warranty deeds and all this garbage, right? Can't divest. Okay, so that's deed. So now that we know what deed is, now we go back to this. A bit of deed history. In medieval England, title to land was conveyed in fee simple by a feoffment with livery of season. The essence of this was a public ceremony performed before witnesses called a livery of season. The seller and buyer, fee offer and fee o fee, met on the land, where the seller gave to the buyer something symbolic of the land, like a twig or a handful of earth, and made an oral statement transferring the land. No type of document was needed for this sort of transaction until 1677. About exactly 10 years after the Sestrique Vi Act came into existence. Anybody question that a little bit? Yeah. When the statute of frauds required one for all transfers of land titles. So what was the attorney doing? The attorney was making attorney work product doctrine for himself. He said, oh, you can't do it without a written document, right? Well, was everybody literate back then? No. So then automatically anybody that wasn't literate could then not own land without having to go to an attorney. Makes pretty good business for the attorney now, doesn't it? The statute of uses in 1535 effectively created an alternative form of conveyance, the bargain and sale, because this is what we get into. This is what they're doing. They're bargaining and selling the use of the thing. The seller The bargainor basically promised to deliver the land to the buyer, bargainee, in exchange for a payment. The statute of uses provided that any written document transferring use of the land automatically transferred the title as well. Well, okay, fine, but then when you get into the Torrens registry system, that gets altered. The bargain and sale contract was useful because, unlike livery of season, the bargain and sale could take place in private and at more convenient location than on the land itself. However, it had the disadvantage that the statute of enrollment of 1536 required that a bargain and sale contract conveying land not only be written down, but also that the deed be enrolled in a public registry. Because the statute of enrollment, what is that? That's Roman civil law working its filthy way back into, or over the top of, the English people. Now, the importance of understanding about the Roman registry system, I covered that ad nauseum, so I'm not going to rehash it here. The point is that when we transfer land between man, man, woman, woman, as sovereigns, and we hold the record to that, there doesn't have to be any magical third party, the magical state, or the filthy cult of Rome, demanding that transaction be known to them. Period. Full stop. Why? Why is it any of your damn business what land I transfer wherever, right? It's none of your business. Never has been. It's a private matter. What they want is they want everything on the rolls. They want everything on the Roman rolls so that they can control everything. That was Rome. Just keeping records of everything and making sure that all their slaves were in order, right? Nothing has changed. They've just transferred and slowly transferred that system back over to us, where at the Revolution, we told them all to go fuck off and set up our own system of American jurisprudence, where all of us are sovereign and we hold our own courts and the magistrates are subservient to us. And that a petite jury is the proper tribunal, and that proper tribunal, once it makes a decision, cannot be altered, except by what? The common law. All right, to continue. Another type of conveyance used at this time was the grant, which was used to convey an incorporeal or future interest in the land. Due to a peculiarity of the law, a deed of grant could not be used to convey a current interest in land. However, a special form of grant called a release could be used to convey a future interest to someone who already had a current interest. The modern version is called a quitclaim. How many people do you know that have quitclaim deeds? This resulted in a very popular form of conveyance called a lease and release. Two agreements were required. First, a bargain and sale contract, because that put it under the statute of uses, was executed by the seller in conveying a lease on the land. Unlike an outright sale, leases did not require enrollment in a public registry. The seller then separately executed a release to grant to the buyer, who was now his tenant, a revision of the seller's interest. Voila! The effect was to transfer title to the buyer, since he now owned both the current and future interests in the land. Current and future interests. Uses. I want the title. I don't care about your use. I want the title. Because if I own the title, no one can use it but me unless I allow it. Right? That's the point. Which is exactly what the corporate state thinks it's doing with the Torrens registry system. All right. Although it might seem that a bargain and sale of land was more straightforward, it did require livery and enrollment, meaning livery of season, meaning to go and actually, and then enrollment, meaning the registry of the deed. A bargain and sale of a lease required neither. The lease and release thus became popular among those who wished to transact sales in privacy. But what they weren't realizing is that the actions of what they were doing were even less powerful than the filthy setup of, oh, you still got to come in and do the enrollment. The most powerful is a allodial title transfer privately. And sure, you can go record the deed if you want. That's fine. That's not a big deal. There's no transfer of jurisdiction to the county simply because you recorded a deed done on public record, that's irrelevant. Because allodial title is absolute title. It's not secondary. It's not an aspect of usufruct. It's not, you only get to use part of this and not, say, the mineral rights. It includes everything. So anyway, so this is what they were doing. The attorney was pushing this to go less and less and less and less and less as far as the highest levels of law are concerned. Let's put it that way. It's the best way to think about it. Okay, so the lease and release thus became popular among those who wished to transact land sales in privacy, such as aristocratic families dividing up ancestral estates. This was obviously a moot point in America. In fact, the lease and release was heavily used in England well past the American Revolution until an 1845 statute permitted the use of grants to transfer title to land. Okay. Forms of deeds in colonial America. In America, deeds for land were made in all these forms. For instance, the first deed book for Surry County, Virginia, covering deeds recorded 1652-1671, contains deeds executed by each of these methods. The specific method used for the conveyance was far less important in America than in England. The advantage of privacy was favored. Lease and release conveyances in England was eliminated by the actions of colonial legislatures, which required public recordings of deeds regardless of form they employed. Again, it's not a problem recording the deed done. I don't have a problem with that. What I have a problem with is them coming along with their filthy Torrens registry system and saying, you have to register the title under our Torrens registry system. That is different. That is where they then have the quote-unquote right to then tax it because you've registered it. If it's not registered, they don't have the right to tax it because it's allodial. But anyway, to continue. Virginia, for instance, required deeds for land to be publicly recorded as early as 1640. The most common form of colonial deed, at least in the southern colonies, was the bargain and sale. Livery of season and deeds of feoffment appeared to have become steadily less popular to the point of becoming quite rare by the end of the colonial period. Now, why livery of season ever was worked out of the society, you can see direct connection to the fact that that's what the attorney wanted, because that was the highest title to land, because that transferred allodial title. Lease and release conveyances seem to be more popular in some states than others, perhaps more reflection of a preference on the part of the individual clerks or attorneys who created them, rather than any adherence advantage to the method. Right? It's funny, I thought about that, and then the next sentence literally stated what I just said. Lease and release conveyances seem to have been more popular in some areas than in others, perhaps a more of a reflection of preference on the part of the individual clerks or attorneys who created them, rather than any inherent advantage to the method, because there's no advantage to it at all. It's a lower title. It's right in your face right here. I'm sure an attorney wrote this. This is kind of them boasting, perhaps. Or if it's somebody of more of a forensic historian as far as law is concerned, I would have clearly written that too, because obviously I said it just before I read the sentence. Again, who is your mortal enemy? The attorney. Always, always, always the attorney. The attorney is always your mortal enemy. Always will be. Always has been, always will be. Because you'll always see things like this. If this singular little document here doesn't prove it, I've covered this hundreds of times in dozens of different treatises on law, to their actions, to who they are. Okay? The attorney is always your mortal enemy. Have nothing to do with them. Do the deeds yourself. Put them under contract so that they cannot administer your estate. That's the point. And that's what the Vocational Science of Freedom status docs do, is that they put the attorney, all of the attorneys, under contract. So if they attempt to administer your estate, and again, to reiterate here, an estate is everything that a man or woman owns in law. You want to think of it more as an aspect of an interest. So it's all of the interest of everything that you own in law. And yes, it can be considered to be an area of land, which some people refer to as the word estate, as an area of land. But the proper way to truly understand it, particularly how we have it written in our documents, is that an estate is everything that a man or woman owns in law. Okay. So anyway, okay, in Virginia at least was a seemingly there was seemingly no legislated preference as to method nor any local advantage of one form over another. Well, until the Revolution, because then you're all sovereign. Then the whole system would have had to change, or if a sovereign went back to this filthy system of uses, then the sovereign was waiving his right to hold land in a allodial title, absolute above all others. You have to pay attention to transition when it comes to law. You have to pay attention to when these things happened and what effect they had over then and over time. All right, so the statutes dealing with deeds persistently lump all the various types together, singling none out for special treatment. Again, until you get to the Torrance registry system. Regardless of the method used, deeds were constructed in the same basic way. Genealogists know that the names and residence of the grantor and grantee, the consideration, the description of the land, and the dower release are all valuable genealogical clues. We don't always pay enough attention to the language describing exactly what is being transferred and to whom. Well, who's we? We don't always pay enough attention to the language describing. Attorneys don't pay enough attention, right? Because they don't want to. Because they don't want this system. They don't want an actual, well, we don't want a quote-unquote system either. We want a method to transfer title that is allodial, that has nothing to do with the attorney. That's what we want, and that's what we're going to have. Because once you do the status doc set, there's nothing they can do to come over the top of you, unless, of course, they want to pay the $300 million bond or get dragged into binding arbitration. But I digress. Types of interest in land and operative language. Genealogists normally need to be concerned with just a few basic types of interest in land. Which types of interest is conveyed by deed depends on the specific language used. These types can be viewed heretically based on how long the interest in the land is designed to last. Now, again, interest in the land. Absolute title is a allodial title. That's not just an interest in something, that's absolute holding of title of it. Just remember that when we're going through these. The closest thing you get under Roman civil law to a allodial title is what's called fee simple. It's actually called fee simple absolute, but they don't have the word absolute here. They're just saying fee simple. If you look up in Bouvier's and a couple other law dictionaries, fee simple absolute is the closest thing you can get in Roman civil law to a allodial title. But again, you're still referring to it as some sort of use, right? So anyway, fee simple. This is an interest that potentially lasts forever. It was basically unrestricted in that the owner could do as he wished with the land. In particular, he could sell it or devise it to his heirs. The key language in a deed is a conveyance to John Doe and his heirs. It should be his heirs and assigns forever, whatever. Normally, we see a more evolved version that makes it clear that the interest being conveyed was unrestricted. For instance, to John and his heirs, executors, administrators, and assigns forever. These deeds almost always are clear that the interest is being transferred forever, as I said. Now again, the interest is being transferred forever. So you're saying that I have the right, and my heirs have the right, and their heirs have the right to use it forever. Do I actually hold a allodial title? No. Well, there's a problem with that. All right, next one. Fee tail. The fee tail was an interest held by a person and his lineal descendants. It thus could only last as long as his lineal descendants survived. Each generation held what was basically a life interest, with the land passing to a specific lineal descendant upon each death, generation after generation. That's what's called generation skip. It's also what's called perpetuity. The current holder could neither sell the land nor devise it in a will. The key language in a deed, or a will, is a conveyance to John and his heirs of his body. Some more restrictive versions of fee tail are conveyed in a footnote. A person was said to have, quote, died without heirs of his body, close quote, whenever the line eventually died out, at which point the land reverted to the legal heirs of the original grantor. Huh? Reverted to the legal heirs of the original grantor. Right. So if you declare your lands to be allodial in your sovereign capacity, you are then the grantor. Why? Could the United States federal government ever come over the top of you and say, "Well, we granted it"? Who are you? You know, you were holding it in trust for the people who are sovereign, you bastards. And don't you ever forget that. Right? That's the point. Now, I got in an argument with someone one time about the aspect of having a title and transferred from the standpoint that a land patent. And their argument was that you can only quote unquote patent the new thing. So you don't want to be using a patent, you just want to create the title and just go off it. I'm like, well, okay, I could kind of see your argument. However, the new thing is the area of which is now allodial and under the title of that sovereign. So I understood their argument, but I didn't agree that to go back and use and bring forward the original land patent and acknowledge it on the public record and then doing the declaration of allodial lands was somehow or in some way inferior or would somehow in some way diminish any sort of absolute right that you had over the land. So again, fee. And here's the thing. You got to remember the aspect of being a fee. What is the root word of feudalism? Fee. Feudal. Fios. Fidelity. That's fee. There's a higher landlord, right? You've got to pay Satan. You got to pay Baal. Baal, right? You got to go pay Baal. Fee is having a higher landlord. Because you want to get, getting biblical from the standpoint that we have absolute dominion over our lands. God created the lands, He created us, and so biblically, you have dominion over what is yours. And that's what all this is about, because the word dominion is used in Roman civil law, and it is the highest control when you're talking about that. No surprise why Dominion, why the voting machines were called Dominion. They're laughing at you. They're laughing at you because you don't get it. And you need to start getting pissed off about it. And you need to start understanding what these words mean and where they come from and how far back these words go. Next one, life estate. A life estate can only last as long as a particular person lives. The land then reverts to the original owner or his heirs. A deed or will that transfers property to John for his life is conveying a life estate, a life interest. A deed which transfers land simply to John, with no mention of X's heirs, also transfers a life estate. We commonly see a version of this in the case of a husband conveying a life estate to his widow in his will that would then go on to both of their heirs, meaning their children. Occasionally, the life might be that of a different person, as in to Jane for the life of John. The holder of a life estate could not sell or devise title to the land, although they could assign their lifetime right in it, meaning they could assign it to someone else. So again, aspect of use for time. Term of years. Basically a lease. Leases usually used verbs in the granting clause like demise or lease instead of language denoting an outright sale. Exactly. Because we're only transferring the right of use here. We're not actually transferring title. The term could be a specific length of time or an undetermined period like a lifetime or at will. The leaseholder normally assumed the rights and the obligations of the title holder during the term of the lease. In colonial times, these often look like any other deed, and a careful reading of the terms is sometimes necessary to identify them as leases. Huh. A careful reading of the terms is sometimes necessary. That's attorney speak for, we hit it really well, and if you don't go find it, you're fucked. In addition to these forms of interest in land, we also see a variety of other sorts of recorded deeds. Among them are mortgages, deeds and bills of sale for property other than land, and a variety of specialized contracts such as deeds of settlement and marriage contracts. Well, you don't get a marriage contract so much later. But, of course, they're not necessarily talking about here in this little sentence in the colonial times. This sentence is taken out of time context from what the rest of this was talking about up here from deeds in colonial America. Proving and recording of deeds. Deeds became effective upon their delivery to the buyer, right? Because that's a deed done. What did it say when we were going through deed? It has to be signed, sealed, and delivered. Where have you ever heard that before? It's been signed, sealed, and delivered. Okay, that's a deed done. Great. Okay, the public recording of a deed was not necessarily required in England, see above, but colonial legislatures dealt with higher volumes and a greater level of fraud than in the mother country. Well, yeah, like George Washington. No, I'm not making a joke, and no, I'm not being facetious here. George Washington was one of the biggest, if not the biggest, land speculator in colonial America. Now, I'm not saying from the standpoint that he fraudulently did this, but I'm just saying that there was a tremendous amount of land speculation, meaning, because what could Washington do? Washington could march an army out into a new area, clean it out of anybody that might be living there, and then have the state come in, and then he would turn around and do the survey, because that was one of George Washington's first quote unquote jobs. Like when he was 13 years old, he was the chief surveyor for, now don't hold me to this, but I think it was Culpeper County, Virginia. I might have the county wrong, but I know that was one of his first jobs. And at the age of 13, he was the main surveyor of that entire county. What did he use those skills for afterwards? Well, he went a little bit farther west in various different places and then started to land speculate. Right? So anyway, they recognized the need early for a public register of land transactions. So a public register or a public record of recording. See, it says a public register. It's a huge difference between registering and recording. Virginia, for example, enacted statutes beginning in 1640 that effectively required all transfers of title to be recorded in order to preserve their validity. Again, I don't have a problem with recording a deed. I have a problem with registering the title. In 1662, it required even deeds executed in England to be recorded in Virginia. Smart thing. As the first and largest southern colony, as well as the great exporter of statutes, Virginia's acts tended to be copied by the other southern colonies. So basically what Virginia did, all the rest of the southern colonies kind of followed suit. For instance, although few of North Carolina's early statutes survive, one of the first acts of its proprietors was the appointment of a registrar of deeds. Subsequent Virginia statutes clarifying and recording requirement eventually extended it to cover mortgages, most leases, marriage-related land contracts, deeds of settlement, and a variety of specialized deeds. Later statutes also clarified that the recording must take place in the jurisdiction where the land lay. That also is logical, because the county recorder should be the place where the proper record is kept for what? Public notice. So that all of the rest of your fellow sovereigns can go and look it up in the public record and go, yeah, John has right to that. Here's the chain of title. Here's the abstract that goes all the way back to the original land patent. And now, yes, John owns that in allodial title. That's fine. Again, I don't have a problem with record keeping. I have a problem with registering. To continue, deeds first had to be proven either by the testimony of the seller himself or by witness. Virginia initially required the testimony of 2 witnesses. Surprise, surprise. Then increased the requirement to 3 witnesses. No surprise there either. In 1748, once proven, the recording took the form of copying the original deed into a public book. That's where you get the book and page number, where you still go to this day to the county recorder's office and you file your declaration of loaded lands, or you file your Vocational Science of Freedom status doc set. They will give you what? It'll, up in the top, it'll say book and page number, right? A 1656 Virginia statute required all deeds to be registered in a book for the purpose. Funny how they started that, right? Back in 1656. Registered in a book for the purpose. Another good historical note to remind one about the evil of registering things into books is the book called the Doomsday Book, which was the book that William I, also known as William the Conqueror, of the filthy serpent seed line that came over and decided to fuck up England, initiated shortly after he conquered England. He created this book. It was literally called the Doomsday Book. That's what they referred to it as. You can go look this up. It's not a joke. And he forced everybody to register their land in that book. Surprise, surprise, right? So to continue. In general, the buyer retained the original deed with a copy made by the county clerk and preserved in the county record books, which is exactly what still happens to this day. You go down and you record your Vocational Science of Freedom status docs. You get to keep the originals. They make a copy, or they scan in a copy nowadays because we live in the digital age, and they put the book and page number on it first, scan it in, you get it back. Now it's on the public record. Now anybody can go and take a look at it and say, yep, that man has the first thing in his land record is the Declaration of Loaded Lands, or the first thing in this, when I look up this man's name on the public record, it comes up with all of these documents, which are the Vocational Science Freedom status documents, which prove that he has a will, right? Because that's one of the important things that we're doing, is correcting the public record as the presumption that our estates are in probate and are what's called intestate, meaning they do not have a will. In regard to timing of recording, Virginia's original statutes required deeds to be recorded within 6 months of delivery. A 1705 Act extended this to 8 months or 2 years if the seller resided outside the colony. The 8th month requirement remained in force at least through the Revolution, though it was extended temporarily in 1766 and again for deeds after 1771. And that's the end of this document. There are some footnotes here, which are some are interesting. Livery is an archaic form of the word delivery. It's the root word, right? D in French means of or from, like Evelyn D. Rothschild, right? D is not that man's middle name, by the way. It means of or from the House of Rothschild. So delivery, livery is the form of the word delivery. So season or season was originally a word meaning possession. So livery of season thus was synonymous with delivery of possession. That's what it meant. Delivery of possession. Livery of season. Delivery of possession. Livery of season. Sometimes the witnesses signed a statement that they had observed the ceremony, but that did not constitute a deed by itself. Sometimes the witnesses signed a statement that they had observed the ceremony, but that did not constitute a deed by itself. Just some aspects of livery of season. So what does it mean? Delivery of possession in its root form. I hope you guys enjoyed that wonderful little lesson in land history, and I hope you learned something from the standpoint of these terms. And again, whenever you go through a document like this, the first thing you want to do is pull up Bouvier's Law Dictionary, and you want to look at and pull down any word that you do not know what it means. You always want to go to Bouvier's first, because that's the dictionary you always want to use. But then if you want to cross-reference it and get maybe a little bit more information into the Roman civil law side, the commerce side of the word, then you can then secondarily go and pick up, say, blacks, or go and pick up and look at a banking dictionary if the term happens to be something that would be in that realm or that field. So let me check chat, see if anything's okay. Definition of tendum. That'd be an interesting look. What does that say? By the way, good throw up there, Rounds, because this is a really fun dictionary. The one thing about the law.com, this dictionary is really fun because they've incorporated so many other dictionaries into it that I have found that when I look up a word here, there's a lot of times that I'll find stuff that I can't find in other places, particularly really interesting Latin terms. This dictionary, this online one, the law.com, has a lot of hard to find Latin phrases that you really can't find any other place. And you can find them very quickly as well. So anyway, so what is this? Tenendum, conveyancing, is a Latin word which signifies to hold, to. It was formerly that part of a deed which was used to express the tenure by which the estate granted was holden, right? But since all freehold tenures were converted into scoage, yeah, the tenendum is of no further use even in England and is therefore joined to the headendum in this manner to have and to hold. Okay, so fun. Thanks, Rounds, for putting that up. Yeah, dominion, that's another good one. Thank you for putting that up. Lordship, noun. So lordship, sovereignty, or supreme authority from Old French, dominion, rule, power, and directly from medieval Latin, dominionem, nominative, dominio, corresponding to Latin, dominium, property, ownership. From dominus, lord, master. That's important, that you're the lord over it. From domus, house. So if you have dominion and you're the paterfamilias and have dominion over what? Your house. Or you're the materfamilias and have dominion over, from domus, your house. So dominion. Dominion is literally lordship over one's house, is literally how you can break that down. If domos is house, it's house, ruler over the house, so dominion, right? From pi, root, dem, house, household, right? In law, power of control, right of uncontrolled possession, use, and disposal. Because if you have dominion over something, you can dispose of it. If you have dominion over your house, you can burn it to the ground if you want to. Your house. From 1510, as territory or people subject to a specific governmental control. Yeah, great. So they're talking about that the government or the people, or like a king, has dominion over them. Well, in America, we're sovereigns, so we have dominion over everything. British colonies were often called dominion. Really? I did not know that. That's fascinating. Hence the Dominum of Canada, the former Title Act of 1867 Union. Dominium Day. Really? The Canadian national holiday and celebration of the Union, and Old Dominion, the popular name for the U.S. state of Virginia. What? I did not know that either. The popular name for the U.S. state of Virginia. Huh. Old Dominion. Really? Fascinating. Doomsday Book, thank you. That's a good reference. You guys can go check that out as to what I was talking about as far as Doomsday is concerned. So thanks, Rounds. And oh, thank you. Is that the exact place where I copied this from? Yeah, it was. Great. Okay. Thank you, Rounds. I'm assuming you just back searched for it. So yeah, so that's the place where I grabbed it from. All right, guys, that's good. So I thank everybody for showing up and coming, and I hope you learned something. And I hope you make sure to pass this on. Make sure to give somebody the link to the Vocational Science of Freedom YouTube page. And I hope all of you have a wonderful evening and stay free and stay sovereign.